is State of Ohio versus Deprise. Case number 28-914. State of Ohio has also waived oral argument in that case. So we will hear from Attorney Van Dyck on behalf of Mr. Moore. We've read the briefs and are ready to proceed. You'll have 15 minutes. Let me reset the clock here. Okay, you may proceed.
Thank you very much, Your Honor. May it please the court. I am Alan Medvick. I represent the appellant in this matter, the defendant, Deprise Moore. Deprise entered a plea in this matter and was sentenced to, I believe, what amounted to a maximum sentence on this of 5.5 years. The sole issue raised because this is an appeal is concerning the merger of the offenses of the failure to merge the offenses of hit and skip at a felony level and the aggravated vehicular assault. I will tell you that in my brief I cite to one standard of review in this matter, and the state indicates to a standard of review under the State v. Ruff out of the Supreme Court. That is the later holding. I would agree that the three-prong test articulated in the state's brief is what is binding in this matter at this time.
Ruff is the current law.
Ruff is the current law. This is a case, this is a matter, a merger issue that has gone up numerous times, and I apologize for using older law in my initial brief. Even under that subsequent, under Ruff, I believe that these sentences should have merged, and my client was improperly extended beyond the time permitted. And I believe that the review of sentencing at this point, and under even a maximum sentence review, is a abuse of discretion standard by the trial court, and a clear abuse of failure to fall within the sentencing guidelines. I think we are outside of that in this case, based on what should have been a 5-year maximum is now extended beyond that time. The reason for that is that at a felony level, there is an element in the hit and skip that it requires an element of serious physical harm, which is an identical element to every element of aggravated vehicular assault. That to be at these levels and have this offense, the serious physical harm, the actions had to be identical. You could not commit hit and skip at the felony 5 level without committing aggravated robbery or aggravated vehicular assault. I apologize for misspeaking. That the subsequent, the additional time for the felony 5 hit and skip in the ag is caused by the same serious physical harm that creates the aggravated vehicular assault. So there is no way to have, and then under the Ruff standard, the 3 things you were looking for are the offenses of dissimilar import or significance. Is there a separate identifiable harm here? One auto accident, there's one injury, there's serious physical harm to my client. And the reason I articulate it in that way is that there is a separate charge for leaving a scene for the hit and run incident. That is a misdemeanor in almost all cases. That is a separate harm at that level without causing serious physical harm, without creating an aggravated vehicular assault. That is a misdemeanor charge that would have merged into this charge. It's unquestionable that to reach these 2 offenses in this manner, there has to be this unique one binding act. There is no separating harm for the hit and skip at this level from the aggravated vehicular assault at this level. These are identical offenses. They are merged offenses. They are of similar import. And again, there's no question that there were offenses occurring at the same time. One accident, one departure. Everything that happened here happened at the exact same time.
Counsel, I just wanted to ask a question in regard to that, because your client pled guilty to these offenses.
He did absolutely plead guilty to these offenses, yes.
So, and it wasn't raised, that's why you're arguing plain error.
And I have no recourse but to argue plain error.
Right, I understand, but my point is, how do we know exactly what's going on with the facts and everything, since there's probably not a record of...
There is significant evidence put in to the, there is a significant sentencing record here. numerous people testified, including my defense, as to the accident, as to what the harm was, as to, and even just on the level, on the basis of the law here. I don't think there's wiggle room here to separate that out. I think that these are, I understand the state's argument, and I understand that your question is that these are factual determinations, but in this case, this is practically a legal determination that to have this offense, these offenses in this way, you almost are at a point where it has to be a determination of a merger question.
How do you respond to the state's argument that there's a separate animus when you decide to leave the scene of an accident?
And
You've got the injury, the accident, the injury,
and again,
and then the
My-
separate animus.
my issue there is with the separate animus for a hit and skip is a misdemeanor offense. That you cannot cause, that, right now I'm talking about the creation of a separate, an element that has to be here. You can't reach this level without serious physical harm, without a unifying act there. And that is that's my position.
Counsel, wasn't he indicted as a felon?
Yes. He wasn't, I think, pled as a felony, he pled all of this act.
I needed to clear this up for me.
Okay.
Because I thought your argument was something different,
Uh-oh.
and I actually still think it's something different.
Maybe I should
But
ask.
your argument, so I'm gonna tell you what your argument is now.
Please do.
Your argument, it sounds to me like now you're arguing that this hit skip should have been a misdemeanor charge.
I am arguing that I am not arguing that this should have been a misdemeanor charge.
Okay, then let me go to what I thought your argument was,
Please
and
do,
maybe that's
because
what it is.
I want to clarify that.
If I'm correct, the ag vehicular assault is an F5, but there are several things that can enhance it, and in your client's case, it was enhanced to an F3, is that correct?
I believe that it is the other way around.
Okay, go ahead.
The misdemeanor, the hit and skip is a misdemeanor in most cases that can be enhanced to a felony offense based on serious physical harm. The aggravated vehicular assault is a felony based on the serious physical harm. That's how you get to aggravated harm. I am not arguing that this case lacked serious physical harm, and so therefore should have been a misdemeanor. What I'm saying is that but for the fact that but for the serious physical harm, which is a necessary element, you cannot commit both of these offenses separately. That I could not commit this level of hit and skip without the presence of serious physical harm, which is a necessary element to both offenses. Without the aggravated physical, without one, I can't have the other, and which is the nature of murder. That is my argument, and I understand that there is a way that this could have been, but it's a way that a misdemeanor hit and skip would not merge with aggravated physical harm, or with aggravated vehicular assault, because you're walking away from the scene.
Except that the statute of the ag vehicular assault, when it talks about enhancing it, and one of the reasons could be the hit skip,
Yes.
specifically uses the word course of conduct,
Right,
which sounds like merger.
and so now we're in, and that's right, and so you've got an enhancement at the hit and skip level, which I believe is also, I believe that's the reason for the enhancement here, is that he left the scene. And I would have to check the record on that, I'll leave that to you. It's
They
been-
use
They-
the suspended license to
They use
enhance it here. So my question is, does that
And
make a difference?
I will leave that they specifically articulate that in the
Indictment.
indictment.
You're talking about enhancing the vehicular assault within the US.
And that is something I will leave to you at this point. That right now, I know that there are a list of offenses, one of which was this, but also I would say that this is but again, here, we're looking at a matter of murder based on the level on the enhancement of the aggravated assault, the hit skip. I think that we can't reach that point in either, and I know that both of these are enhanceable offenses, and yes, the DUS is out there to enhance the other charge, the aggravated. But there's no way to enhance this to a felony level. And without that enhancement, this would have been a misdemeanor, which would by statute have been merged into the 5 years, and I believe that that should have been its maximum sentence. If there are no other questions, I've surrendered the balance of my time.
Okay, there are no other questions, so thank you for your presentation on this case as well. Attorney Van Dyke, and we'll take the matter under advisement, issue our decision, and the clerk will certainly mail you a copy of that decision promptly, and you can also find it on the Supreme Court of Ohio's website. Thank you for your arguments this morning.
Thank you.